Thank you, Martijn. And again, good afternoon, ladies and gentlemen. My name is Jan Birkhoff, member of the National Valuation Team of the Netherlands Customs. And this team, actual now 17 persons, acts as a kind of linking pin between policy and implementation in the field of customs valuation legislation. And this morning, Federico talked about the Dutch approach in cases of related party transactions and year-end adjustments. Well, that is just one element of our work. And the Dutch approach is working very well, I think. But I had to explain one thing. You cannot use the Dutch approach without approval in advance from the National Valuation Team. So in advance, we gave an approval to do that way, as Federico told, and then you can use the so-called Dutch approach. So as such, together with my colleague from the Ministry of Finance, I attend the meetings of the committees at the WCO and at the EU. And during the presentation, I will tell something about the working methods of the committee, and I will start with the WCO committee. And unfortunately, I have to do this presentation by Teams because of a COVID infection. So that's the way. That's why I'm not in the room for the moment. The second slide, please. These are the topics. The first, I will discuss activities of the Technical Committee on Custom Valuation of the WCO, and then in the second part of the presentation, I will tell something about the work of the Customs Expert Group Valuation of the EU. Let's start with the WCO Committee TCCV, and you see the building of the WCO in Brussels. It's always in Brussels. And next slide, please. Well, it's a WTO agreement, but the mandate of the TCCV is laid down in the agreement of the WTO in Annex 2 of the agreement. And the TCCV shall inter alinea, so it had to do more, ensure at a technical level uniformity in interpretation and application of the custom valuation agreement. And in Article 18 of the agreement on implementation of Article 7 of the GATT, this describes two institutions. There are two committees, a committee on custom valuation, but that's a WTO committee, and that's in Brussels, in Geneva once a year. And we have a technical committee on custom valuation, and that's at the WCO in Brussels. And that committee is important for us. And those committees are necessary because rules applied by administrations all over the world give always differences in interpretation due to, for example, translation in own languages, or to economic situations, or to cultural differences. So it's necessary to have a committee to try to have uniformity in interpretation and application of the agreement. Next slide, please. The WCO committee meets twice a year at the headquarters of the WCO. You saw the building. It's a beautiful building, but we are always in the basement when we discuss all the situations. There are no windows there, so we can completely concentrate on the discussions. There are members and international organizations and that are together to discuss all kind of technical situations. And the observers that are, for example, the ICC, International Chamber of Commerce, WTO itself, the OECD, but also members of the WCO who are not members of the WTO yet, and sometimes international governmental organizations. That are the observers, and of course the members of the WTO. And the decisions made there in the committee are always by consensus, although there is a voting procedure the committee decided to have only decisions by consensus. If there's no consensus, there will be no decision, no instrument. And if there is a decision, then we can have an instrument, and those instruments are issued based on questions raised by members. So a member raises a question, there will be a discussion at the end of the discussion, there will be a decision by consensus, and there will be an instrument. Next slide, please. And there are different instruments. You can have an advisory opinion, you can have commentaries, there are explanatory notes, case studies, and studies. And it depends on the answer on the question, if it's an advisory opinion, a commentary, or an explanatory note. An answer on a question to a particular set of facts is often an advisory opinion. A commentary is often an additional guidance to the text. Explanatory notes gives a view on a question of a general nature. Case studies, well, it's the word, it's already said. Often complex sets of facts based on an actual commercial transaction. And then there are studies, a few studies, the examination in depth. But the most important are the first four instruments. Next slide, please, Martijn. Those instruments are not legally binding, but they are very helpful guidance to customs administration and to importers and other people who are interested in custom valuation. And of course, they're leading to a more consistent interpretation of the agreement. Next, please. And besides that, on a regular basis, there are theme meetings focusing on a specific issue, and there has been a team meeting on the issue of undervaluation. That is, of course, a major challenge for many customs administration. Well, we've discussed this morning already. It's not only for the developing countries, but developed countries have the same problems. Can I have the next slide, please, Martijn? Okay, of course, during that team meetings, there are subtopics. Often it is about practical use of risk management data to combat undervaluation, tackling under or over invoicing, establishing an effective control strategy, and the challenges of the informal sector. Of course, there are a lot of members who have struggled with the informal sector. This morning we have had already an example of the two. The purpose of this team meeting is to learn from each other, from each other's working methods, to understand the problems an administration has to encounter, and of course tips and tricks. So often good practices and experience will be discussed, shared. And then now the next, please. Then we'll go and take a closer look at some instruments. And we start with advisory opinion 2.1. And then it said the price lower than prevailing market prices for identical goods. Is that undervaluation, yes or no? The technical committee said, okay, the mere fact that the price is lower than the prevailing market price for identical goods is no cause to be rejected for the purpose of Article 1, the agreement, the price paid or payable, the transaction value method, the most important method. And Article 1 is for the EU, Article 70 of the UCC. So even though there's no explicit reference to undervaluation, it's always in the discussions. Well, maybe it could play a role. It's a background in discussion. Next one, please. There's an advisory opinion 10.1. The treatment of fraudulent documents. There was a question about how you can treat fraudulent documents, and is it necessary to accept them, yes or no? The committee said an administration cannot rely on fraudulent documentation. But invalidation of the customs value will be a matter for national, in our case, union legislation. And for that part, Article 140 for the implementing act of the UCC is important for us. So there's a right for the administration to satisfy themselves to the truth and act of any document and statement. So that's a right. Then we have another advisory opinion. This about the burden of proof. Burden of proof in the course of a determination of the custom value on the importer, yes or no. Well, the burden of proof, we discussed this morning, but the administration can expect full cooperation of importers and inquiries concerning the truth or accuracy, but the rights depend on national laws and regulations. So there is a right, it's to be a right on a national scale to say, okay, what kind of cooperation do we expect? Let me see, let's see, paragraph 6 of Annex 3 refers to that right of national administration. So we have always had the possibility to ask something more than they already have given to us as customs. Next, please. Let me see. Yes, you see commentary. Dumping. Dumping is not the same as undervaluation. That is decided in commentary 3.1. It said the general introductory commentary to the valuation agreement says valuation procedures should not be used to combat dumping. So treatment for valuation of dumped goods is the same as the applied to goods imported at a price below prevailing market prices for identical goods that we saw before in advisory opinion 2.1. So dumping is no reason to reject the transaction value as such, and no adding an extra amount to the transaction value to take account of the dumping marge. You had to do it on the other way around. It's not with the custom valuation agreement, but with other measurements. Okay, then I will discuss a practical example about a good purchase in flash sales that has been discussed in the TCCV, valuation of imported goods purchased in a flash sale. Well, flash sales are promotional sales offered in short term and at highly discounted prices to attract potential purchasers. Flash sales can be conducted on the traditional market, but often through e-commerce. But in this case, the buyer bought a smartphone for, I think, $11, and the normal price was $200. And then, of course, the question starts from, okay, can we accept that price of $11? There was no sales contract, only proof of payment. They're limited in quantity and offers, of course, because the flash sale is for a short moment. And not available to every buyer or purchaser, no, only for the buyers who can buy something in that short period. Well, in this case, can we speak of undervaluation? Again, it comes back, is this undervaluation, yes or no? If such goods are brought and declared for free circulation. The question was rephrased in, could a highly discounted price be accepted as basis for custom valuation under Article 1, the transaction value method? And so, if so, could the discounted price be used to determine the transaction value of identical or similar goods? That's, of course, the second question. If you accept the price for an Article 1 situation, can you use it for Article 2 or Article 3 situation? Well, the view of the committee was in general, and that's, I think, well important. Value of the imported goods should be based on simple and equitable criteria consistent with commercial practices, and agreement continues to be the only international legal framework for customs valuation. Maybe old-fashioned, maybe not up to date, but it's the only international legal framework. So its provisions must be applied in respect of imported goods purchased both on the traditional market and through e-commerce. That is maybe a problem, but that's the way the committee sees it. And basis for the transaction value is the price actually paid or payable for the imported goods. And on the next slide, Martijn, the discounted price for imported goods purchased during a flash sale is accepted as base for the custom valuation. And the mere fact that that price is lower than the prevailing market price for identical goods should not cause it to be rejected. Well, we've seen it at advisory opinion 2.1, so that's more or less the same phrase, of course. And accordingly, the custom value of goods purchased during a flash sale is the transaction value of the goods in question, provided the conditions of application laid down in Article 1 are met. That's always the case, so that's the same in flash sale situations. It has been an advisory opinion 23.1. So you see that during the meetings of the WCO committee TCCV, there is not expressly a discussion about low value as such and undervaluation, because it's very difficult to have a case to describe in general. I will come back later on that. But in more or less different opinions or other instruments, you can see it in the background. Okay, maybe we have to do with undervaluation, yes or no. And then we will go further. The second part of my presentation is about the custom expert group valuation section of the EU. You see the beautiful flag of the EU. And the custom expert group, yeah, next, Martijn, sorry. It's based on, the custom expert group itself is based on the regulation number 952, that's the UCC, and the Commission regulation 2446 and 2447, that's the Implementing Act and Delegated Act. The three of them altogether is the custom legislation we had to deal with after May 2016. Next slide, please. What is the function and the task of the custom expert group? Well, that's more or less the same as the TCCV committee. It shall ensure at the technical level, again at the technical level, uniformity in interpretation and application of the UCC, the Implementing Act and the Delegated Act. And that is, of course, only for the 27 members of the EU. Of course, the outcome of these discussions are not legally binding, but again important for the uniform interpretation, and is accepted by the Court of Justice that it's important for the instruments are very important for the uniform interpretation of the legislation. Next, please. What is the challenge for the EU? Of course, the challenge for the EU is to ensure a uniform application of the legislation by all customs administration. Act as one. 27 different organizations had to act as one. That's not easy. So there are two major tools available to administrations and companies and trade to ensure the harmonized application of the rules, the European rules on custom valuation. That is this twice a year, a meeting of this group, of this committee. And during the meetings, the member states or the Commission put topics on the agenda for discussion. And when there's an outcome, when we have a conclusion about the discussion, there will be an instrument, and that instrument will be published in the compendium of custom valuation texts, and that's it's to fight for everyone. It's public compendium, so everyone can read it. It's the newest version is from 2021. And of course, there are a report of the discussion, and you can find the reports too on the website of the EU. The instruments and the decisions are always by consensus, so we normally spoke, we have no voting procedure. It's somewhat different than other committees at the EU, but for the custom valuation committee, there is no voting. So we try to convince each other, and at the end we will have a consensus. Next, please. As I told before, one back, please, Martijn. Yes, the compendium is the results for the consideration, as I told you, and there's some outputs. We have commentaries that give guidance how to apply a specific provision, and we have conclusions, the results of examination of particular practical cases. So you have commentaries and conclusion, but the outcome is that it's we can use them both, of course. And now the next slide about the other activities of the committee from the EU. Sometimes we have project groups on specific topics. A specific subject is discussed then, elaborated, and proposals are made by a number of member states and the Commission itself. Often investigating a specific topic, and the results are shared with the complete committee, and this committee can accept the recommendations and it can go further in the line if necessary. So we have had the project group preparing possibilities for binding valuation information in the UCC, and at the moment there's a project group reviewing and updating guidelines regarding combat undervaluation. There are already guidelines, but they are from I think 4 or 5, maybe 10 years back. So we had to be actual, to make actual because of the new court cases, new legislation, new views. So it's important to have guidelines how to deal with undervaluation as such. It's for internal use, of course. And what are the goals from this committee as such? Well, I told you uniformity and application of the secondary methods. That's the goals for the working group on undervaluation, guidelines on undervaluation. We try to reach uniformity and application of the secondary methods in relation to the use of databases. And do you use them? How do you use them? Can you use them? And what phase of verification or control do you use it? What kind of information and documents concerning the declared value are important? And then the burden of proof, the verification of the declared custom value. What do you want from importer? What do you do for yourself as organization? Are you active? Are you passive? Well, I think we are an active organization, administration. So of course, if there is information from the importer, we had to see how we can implement it in our vision. So important because of the burden of proof. We discussed it this morning. Article 140 of the UCC Implementing Act is a very important part for this. If you do not accept the declared transaction value, then you must have reasonable doubt. And you may ask to supply additional information. And then if the doubts still remain, then you have the possibility as customs organization to decide that the custom value cannot be determined in accordance with Article 70, the transaction value method. So you have to follow the steps. And if you do not follow the steps, well, I think then you can have problems in appeal and so on and so on. Next slide, please. I come to my conclusions that undervaluation is a worldwide phenomenon. A tool to combat undervaluation is, besides risk management, of course, the customer valuation agreement. You've seen it before, but due to different situations regarding undervaluation, there's not as the one-size-fits-all solution. And this morning we talked about two undervaluation cases in it's case studies from the WCO. 13.1 declared value lower than the declared value of the identical goods, and 30.2 declared value was lower than the raw materials. In both situations, they used database, they used information outside the import itself. By case study 30.1, it's not only that the price declared value was lower than the declared value of identical goods, because if that was the case, then you had to use advisor opinion 2.1, because there had to be, they said, okay, also, even if the price is lower than the normal price on the market situation, it's not a reason to reject it. So in this case 30.1, there were more facts and no administration, cash payments, and so on and so on. So the fact that the price is lower than the regular price is not enough as such, and that's, I think it's described in case study 13.1 too. And we have, of course, a situation of undervaluation and occasional cases that you have to deal on a different way than if there is undervaluation on a structural base, like the garments and textile and the shoes from the Far East. I think then we had to use other methods. Not we had to use all the same method, but you had to encounter it on a different way than if you have an occasional fact of undervaluation. Therefore, I think one size fits all is not a solution, although we try to find a solution you can use in general. I think that will be very difficult to see all the different kinds of undervaluation in the practical side of the world. That will finish my presentation for today. Thank you for your attention.